Hello, welcome to this month's LinkedIn Live. If you haven't been here before, I'm Erin Austin, founder of Think Beyond IP, and I do these LinkedIn Lives every last Wednesday of the month. So whether there are 4 Wednesdays or 5 Wednesdays in a month, there's five, right? They're on the last Wednesday of the month at noon Eastern. And so these are also recorded as podcast episodes for those of you, I know some people who could make it today. You can find the recordings on my LinkedIn Live profile, and they're also audio on Hourly to Exit, and the video you can find on my YouTube channel. And so this month, we're talking about how to copyright your expertise. These LinkedIn Lives are about how I help experts protect their expertise through copyrights and contracts. You should know that I do take requests. Always feel free to send your questions to me. And if I think they'd make a great LinkedIn Live, then we shall have a LinkedIn Live about it. So let's get started. At the end of this, of course, there will be time for you to ask your questions. Typically, I like to keep these to half an hour. We can definitely go over if anyone wants to go over. And because the nature of sometimes the questions that I get, that if they are too specific to your particular concerns, then that crosses over into legal advice, which I cannot give you on LinkedIn Live, but I can answer questions about the copyright law and about the process. I look forward to hearing your questions. So, how to copyright your expertise and stop your competitors and former clients, because sometimes we have problems with that, from stealing your stuff. So, first, quickly, an overview of the copyright law. So, of course, everything I'm going to talk about today is going to be with respect to the US copyright laws and on a federal level. There are different laws that apply on a state, like you can actually get a state copyright, which is common law copyright. But we're talking about the copyright protections that we get under US copyright law, the kind that you probably think about. Those are the federal US copyright laws, and that's what we'll talk about today. And so, what are copyrights? So, basically, copyrights are the exclusive bundle of rights. It's not just one right, it's a bundle of rights that the owner of the copyright has in connection with the exploitation of that work. And I'm going to refer to the copyrighted material as the work. And we will talk more about what that means, but that's the terminology that I'll use. And so, with respect to the work, the copyright owner has the exclusive right with respect to reproduction, with respect to creating derivative works. That means taking a book and turning it into a movie, to distribute copies of it, to make copies and distribute it publicly in particular, to perform it. So a screenplay, a play, the right to perform it, that is a copyright. To display it, if it's artwork, the right to display it publicly is a copyright, and the right to transmit it. So music, the right to transmit music over the airwaves, that is a copyright. So that bundle of rights comprise the copyrights under US copyright law. And when you have a copyrightable material and you're the owner of that copyrightable material, you have the exclusive rights to do those bundle of things. So when is their work protected? At what point does the copyright attach to a work that has been created? So that happens at the moment of creation. Under US copyright laws, the protection attaches automatically. The copyrights are created at the time that the work is created. So the moment that you write something down, you take a photograph, you paint something on canvas, you record something with a video camera, at the time that the work is created, the copyright attaches at that time to the human being who created that work. So, do you have to register copyright? Do you have to register with the Copyright Office in order for that protection to be effective? No, you do not. Copyright protects at the moment, it attaches at the moment of creation. But here we're talking about registering your copyright. And there are a number of reasons why we want to register our copyright. And I always hope people can read things. Of course, I always have it on a huge screen when I make these slides. But why would we register with our work with the Copyright Office when protection is automatic. And there are four really main reasons. There are others, but the main reasons are, and the biggie is the first one, is that it enables you to file a lawsuit to enforce your copyrights in federal court. So even though the rights, exclusive rights attached to you at the time of creation, if there's someone goes out there and copies your book and you want to sue them in federal court in order to enforce your copyright, it must be registered with the Copyright Office first. So that is a primary reason. The second is that it provides evidence that your copyright is valid. If you've gone through the process of registering your work with the Copyright Office, finishing the application, paying the fee, submitting a copy of your work to the Copyright Office, and that has been accepted by the Copyright Office, that provides evidence that you actually have a valid copyright so that you can enforce your copyright against other parties. It also enables you to claim certain statutory damages and attorney's fees. So statutory damages are damages that are dictated by law. So typically, actual damages would be, you hit my car, I have to pay $5,000 to get it fixed, and therefore you owe, my actual damages are $5,000. When there are statutory damages, the law says anytime you hit a car, you automatically get $5,000, you get, let's say, $1,000, even if there's no damages. Like if you hit my bumper, I get $1,000. That would be an example of statutory damage, where the law just dictates what the damages will be, so you don't have to prove what your actual damages are. And there are definitely benefits to that. Let's say somebody steals the entire content of my great American novel that I have sold 2 copies of, right? What are my actual damages if, there's actually no market for my fantastic novel? But with their statutory damages, you stole my entire novel. Statutory damages would give me the amount dictated by law that would be my damages just because you stole my work. So that would be the benefit there. And then if you do have to go to court and sue someone, then that costs money. I mean, one of the reasons people generally avoid taking someone to court is because of those attorney's fees. And so if you have your registered copyright, then you would be able to be awarded attorney's fees as well. I see Tony has a question here. What about someone that copies your program that has been copyrighted and are working your program? Oh, okay. That is going to be a derivative. And so if somebody takes what you have and they create a derivative of it, guess what? That's one of the bundle of the copyrights. To create something based on somebody else's work is creating a derivative. And that is the exclusive right of the copyright owners for anyone to take their work and to create another work based on it. So that would be a breach of your copyright and an infringement, assuming you have a copyrighted work. And then the fourth reason is it puts others on notice that your work is protected, and it lets the world know who the copyright owner is. So you can't see it, of course. Down here, I have my copyright notice that has the C in a circle. The 2023 is when I created this wonderful slides, and they are owned by my law firm, Erin Austin Law P LLC. So that does put the world on notice when we put the C with the copyright notice on the material itself. But let's say it was Hourly to Exit instead of Erin Austin Law, and then go, what's that? And so in order for them to find me, when you register it, then they can find it and find the owner of it. So if they want to license rights to it, want to buy rights to it, want to create a derivative of it, then they know how to find the copyright owner. So how to register a copyright? So there's 3 main steps. 1, you have to make sure that the work is copyrightable. There are rules about what is eligible for copyright protection. That would be something that is copyrightable. That is by far the most complex question, and the majority of our time will be spent there. The second thing, you have to file the copyright application, and you have to file a copy of the work with the Library of Congress. And so just very briefly, I'm going to talk about the application process. You can now apply online, go to the Electronic Copyright Office. For whatever reasons, the URL was very complicated. So you just want to Google it, and you can, for most works, you can register them online, and the whole process would take place online, including the submission of the work, assuming it's digital. And there are step-by-step process for how you actually fill out each of those areas. I want to spend most of the time with what's copyrightable today. And I think what I'm going to do is another one that kind of walks through the application process so you can see it. But I want to start with what's copyrightable. And so that is the electronic version. There's also paper versions back when I was doing film work, we had to print the stuff out and type in the information about the movie and then send a reel of the movie into the copyright office. So you can either do it online or you can do it on paper. The filing fee is a little more for paper, but the application fee itself is not super high. It's between $45 and $85, I believe. That's the registration process. Of course, what I think is really cool, I don't think most people realize this, but when you register your work with the Copyright Office, that copy goes into the Library of Congress. So I think that's pretty cool. Again, I want to spend most of the time talking about whether or not the work is copyrightable. And there are a couple of issues we need to think about. So copyrightable works have to fall into one of these categories. Literary work, that would be nonfiction and fiction. So that would be a book or an article. Musical composition, that would be the lyrics or the notes of music. Dramatic work, like a play, a pantomime or choreography, those are copyrightable, assuming that they've been recorded. Pictorial, graphic, that's artwork, including sculptures. Audiovisual work, that would be like motion pictures or videos. Sound recordings, that would be the recording of a song. The musical composition would be the written part of it. The recording would be when you sing it and record it. Architectural work and source code for computers is considered literary work and is copyrightable. What it cannot be, importantly, is it has to be something that is creative and by a human. And so the things that aren't creative or aren't considered to be created by a human are the things that are going to be excluded. And the Copyright Office will not analyze how unique it is. It doesn't have to be brilliant. It can be pretty ordinary, but still, so long as it is created by a human and there's some element of creativity, then it would be eligible. So things that are not eligible because the Copyright Office does not deem them to be sufficiently creative are ideas, concepts, and processes. I mean, these are not, until we have expressed it in some way, until we have written it down in a book, until we have created a video about it, until we have documented it, and the expression of our idea, the expression of the concept, the expression of the process, that expression is copyrightable, but the ideas itself, the concepts themselves are not. Titles, names, logos, they're not considered sufficiently creative, even if they are very unique for copyright protection. Those can be eligible for trademark protection, but not copyright protection. You cannot get copyright protection for something that is based on somebody else's work, including something that was your former employer's. So maybe something that you got from your former employer and you're using it to create a course based on it. You can't get copyright protection from it if you don't own the underlying material or don't have rights to it. Useful objects like clothing or tools, because sculpture is copyrightable, but if it's something that's just useful, that would not be copyrightable. If it's in the public domain, we'll talk about what that is. Common geometric shapes and things that are entirely composed of information, those are not copyrightable. So in order for it to be eligible for copyright, it has to be in that fixed, tangible medium. So even though we call it intellectual property an intangible, in order for it to be eligible for copyright protection, it has to be fixed in a tangible medium, written down, recorded, painted, sketched, carved. So those things are required. That would mean that things that aren't recorded or put in some sort of tangible form aren't copyrightable. So if you improvise a speech or performance and it's not written anywhere, it's not recorded, that is not copyrightable. ordinary conversation, even no matter how brilliant. Sometimes we say really brilliant things in conversation, not copyrightable. Again, a choreographic work that has not been recorded. And then any of those things, if it is recorded by someone who didn't have the authority to do it. So let's say you're at a concert and it's not being recorded by the performers and they improvise something and you're in the audience and you record it, you can't get copyright protection for your recording. So it must be created by a human. Now that AI is all over the news, of course. Something that's purely AI generated, the Copyright Office will reject that. There was a recent ruling about that of a image. It was a painting where it was 100% AI generated and the Copyright Office rejected it. This will, of course, continue to evolve as AI evolves and we add layers to it. Let's say we ask for an outline, but then we create a book from that outline. Like these are all things that are maybes. Something that's just a natural phenomenon like driftwood, beautiful, right? But you can't copyright it as your sculpture. And things that are just kind of random. In my example here is music created by a wind chime. That's not created by a human, even though the chime is created by a human, the music is not, and probably not copyrightable. And then a sufficient amount of creativity. And so when something does not involve human creativity, and that would be the AI generated element, but also things like footage from a dash cam or footage from, we see those Ring cameras all the time. That footage does not involve any human creativity. We didn't block it. We didn't choose the subject matter. We didn't time it or anything. And so generally that would not be copyrightable. And then if there's only a few ways to express an idea, so even if you express something, I write out a recipe, but there's only so many ways to create chocolate chip cookies. And there's only so many ways to sift flour and mix things and put peaks on egg whites. So generally it would not be copyrightable. And then another one is scènes à faire, which is those beats in a plot that necessarily come from the subject of the plot. So let's take a vampire novel, for instance. I have a vampire novel and he sleeps in a casket. He doesn't go out in the sun. He was afraid of garlic. He lives forever. I can't claim copyright protection in those things that are obviously part of every novel. But just generally, I will say that the copyrightability of the work is going to be one of the more complicated matters. Because there are rules, there are exceptions to the rules. There will always be things like a stop sign that you would think is not copyrightable. Obviously, we know from Andy Warhol that you can take something very ordinary and make it extraordinary and extremely valuable. So there's always going to be an exception to the rules. Anyway, I will stop there because I know I have questions and I want to make sure I get to them. Okay. Is a reader's guide to a book considered a derivative? So this is an interesting question because I know that I see readers' guides to books on Amazon, and I have looked into whether or not they got permission for it. Based on the law, I would consider it a derivative and not fair use. We're not talking about fair use today, but it's not fair use. I would consider it a derivative. You've taken somebody else's work. Now, the question is, how much of it have you taken? Let's say it is a book club guide. I've seen those where you just have a list of questions like this character and that character seem to be at odds. What do you think about that? If you're talking about that kind of thing that makes you go back and read the book and understand the book, you cannot process it without the book. I would think that is not a derivative. That is just something that's a discussion guide versus something that's literally like, I can't remember what they were called, the things with the yellow, with the black. I can't remember what it's called, that they summarize the book. That is 100% a derivative. And I would not do that without permission from the copyright owner. How long does it take to register copyright? So I often see slides from the copyright symbol. The content's not registered. Should we register to propose? Okay, so a couple of things. The process to register a copyright is not very long. Again, it is having your work, confirming that it is copyrightable, completing the application. The application will take approximately, depending, if you have everything that you need and you understand the questions, it would take approximately an hour, maybe 45 minutes to complete the application. Then you need to submit the fee, and then you need to send in the deposit, which would be a copy of the work that you want to have registered, to the copyright office. And so once they receive all of those things, then if they have no questions, they go, great, looks great. It would take about 1 to 2 months for the registration to be completed and for you to get your confirmation back from the copyright office. They may have some questions. If they have some questions, it may go as long as 8 months, depending on the nature of their questions. But it shouldn't take that long. That would be pretty extraordinary. But you should know that, again, copyright protection attaches at the moment you create it. So the registration is because you want to enforce your rights in the copyright office, right? In court. And so you put that C, the copyright symbol, on it to give notice to the world that you are claiming copyright ownership in it, whether or not, how long it takes for the copyright office to get through your application and send you the certificate back, 2 to 8 months. But again, your copyright is attached that whole time since you created it. And should we register your proposals? I would say no. One, is it something that you would want to enforce in court? Would you be willing to hire an attorney to get someone to not copy your proposal? And maybe the answer to that is yes. I don't know the answer to that. But generally, it is those things that would, I want to call them your money makers, the things that provide value to your end client, the thing that the client is paying you for. Now, your proposals obviously entice your client to pay you, but is the proposal what they get value from? Is that what they're actually paying you for? So if they're paying you for your trainings, they're paying you for your courses, they're paying you for your workshops, they're paying you for your workbooks. Those are the things, those that you direct revenue makers, I think would be the place where I would focus most of my attention for registering the copyright. We make copyrightable materials all day, every day. Every time you write a proposal, every time you make a blog post, every time you post on LinkedIn, theoretically, those are all copyrightable works. But you don't want to get so wrapped up in trying to copyright everything that you create, because most of them don't have kind of that evergreen value, that money-making value that the deliverables that you have for your clients do. So, okay. Do you need to copyright each slide, presentation, or proposals in order to protect the contents? This slide presentation, for instance, this is one work. So if that's what you mean, I would register this entire thing. So this would be my work. I will do another one where I walk through an application, but the application will ask you, what's the title? And I will say it's how to copyright your expertise. What kind is it? This is literary. There are some kind of visual elements to them, but I don't claim any copyright protection in the visual elements. So it would be the content. So it would be a literary work. And who is the owner? Who created it? I created it, but the owner is Erin Austin Law PLC, because I'm an employee of it. So it is actually the owner. And so it would be and this would be one work. And then I would send in this entire 19 slides to the copyright office. And that would be the deposit with the copyright office. That would not be in slide by slide. And the same would go for your proposal. I assume your proposal would be, maybe it's a PDF, the same thing. You do the whole thing. And that would be one work that you would register. And by the way, a work, there are different definitions of works depending on what it is. So a book is like one work, but a series of magazines might be more than one work, depending on if you did it before or after it was published. So there's different rules about something that's before it's published versus after it's published, which would definitely be beyond today. But generally, one work would be one unified expression, a song, a photograph, a painting, an article. You can register an entire website. Most people don't, because websites change a lot. For my facilitated decision-making sessions, I craft a design, write a script, create participants, compilation. So when you have more than one, so let's say I have a workshop. So let's say I wanted to register this and I wanted to not just register the slides, but I also wanted to register the recording. That would still just be one work. And so I would choose the one that this is mostly. So I would choose as the type of work, the audio visual. So I would choose the audio visual one. And so I would say it's an audio visual work. It has video and sound. And then I would also say there'd be a place where I could also add the script if I were to do a transcript and the words that are on the slides as well. So you can register more than one category in one application. And so you would just, there are places where you put notes that tells you like what the main one is. That would depend on which application you use, literary, musical, audiovisual, etc. And then you'd also have places to show that you also have other types of work in that same application. If I transition my company from a sole proprietor DBA to an LLC, do the copyright transfer automatically? No, transfers of registered so I'll say this. If you haven't registered them yet, then you would just want to, when you create your LLC, you would make that a contribution. Just like when you create an LLC, you're going to put money in there and you would also contribute whatever other assets you want to contribute to, whether it's your office equipment or your intellectual assets. If you have already registered them in your name, so if I go into the Copyright Office and I see Ellen Grace Henson as the owner of some book, and you want to then transfer that to your company, you would need to register the transfer. So that is another process that you can do through the Copyright Office, where you have an assignment of the rights and you would state what it is. I'm assigning the rights in my book to my LLC, and then you would register that in the Copyright Office. Therefore, the owner, who was currently Ellen Grace, would then become the name of my company. And so you would want to properly register that. The transfer of copyrights requires that it is in writing and signed, so you do want to do that. My sessions are live, no recording. So if there's no recording, then you would register. I assume that you have some materials that you're presenting. Maybe you have a script that you use. It's been written, recorded, it's somehow captured electronically. So it has to be in a fixed medium in order for it to be copyrightable. My main question is that it is compiled from others and other resources because of this. That's correct. It is not copyrightable if you do not have permission, if it is based on someone else's copyrightable materials. Now, let's say I had in here an image that I got off the internet that showed a graph about what types of materials are copyrighted per year. And I could not claim copyright ownership of that graph. Now, I haven't created a derivative of it. I've used it in this presentation. Technically, I should have gotten consent to use it, but it doesn't defeat the copyrightability of my presentation. What I would do is when I register this in the Copyright Office, I would say, I'm registering this presentation, and there'd be a place for me to say, I do not claim ownership of the graph that explains the breakdown of copyrightable topics. So there would be a place where you would disclaim ownership of those parts that you do not own. So whether or not the whole resource is copyrightable or not would depend on whether or not it is a derivative. I think I've hit all of your questions. So if you have any questions, additional questions, you can find me at thinkbeyondip.com. There I have additional resources about what is copyrightable. I do have just on today a assessment that also helps walk you through the question of whether or not your expertise is copyrightable. So you can download that from thinkbeyondip.com. And also I do have ways for you to get legal advice if you need it. If you feel like DIY is not your thing and you would like some legal advice around this, you do have ways to reach me there as well and get your questions answered. I thank you so much for your time. And then also always, I should have on here at Erin at thinkbeyondip.com with any of your questions. Thanks so much.